Kenya, it leaves a big question mark. If for some reason there is a desperation to turn businesses that the Constitution say you should do it within around 80, 100 days into 4 hours, there's a big problem. And that must be addressed. I'm about to finish. So that for purposes of those issues, I agree with him. It just points out to the care that must be taken that these proceedings are not misunderstood. This court in particular must not be understood that it was under undue influence, that we must wear somebody Wednesday, Thursday, or something like that. This must be done within the 4 corners of the Constitution. If that one is not done, my Lord, there would be a huge problem, not just of perceptions, but the huge problem that in Githongori versus Republic, they were talking about. The world, Africa, and everybody else is watching. And what are they watching? How are we going to consider to reduce time, for example, that is expressly set out in the Constitution, into hours? And to do what? To prevent a victim of constitutional violations from urging petitions that are before the court. That should worry the court more. 2 points that are remaining. Mr. Wanyama, I have to choose between Wanyama. Oh, Wanyama is the last one. Now, the issue of Wanyama is national stability. He made several points. That is probably the only one I will address myself. Mr. Ngoya can do the rest. This issue of national stability is actually very important. I agree with him. The issue of the impeachment of the deputy president raises the issue of national stability. For the simple reason, and this is why we must hear the petition, the deputy president, my lords, and as we understand elections in this country and the Political Parties Act, was not just a holder, the way you can appoint Kibe Mungai to be a legal officer somewhere. He was not just a holder of the office of deputy president. There was a political process in order to be able to get power under the Constitution in the 2022 election. That's why the issue of national stability arises. His supporters and those of the president, they came together to form a party. So that, my Lord, over and above, and there is a case which I was privileged to do in 2013, one of the lawyers in that case, this one of conflict management, when Ruto and Uhuru were being prevented from running for presidency in 2013. That case, my Lord, and we did it before 5 judges, it was civilized, it was decent, there was no hurry. But more importantly, what was the issue there? Part of the issues that I was present in that case to urge is this, that President Uhuru and the now President Ruto are not seeking this case by themselves. Because Article 38 of the Constitution says they are doing this. The people's in exercise, their supporters, in exercise of their rights, political rights under Article 38, prefer these people to be their candidates. So what's my point? My point is this. Look beyond Rigathi Gachagua. Look also to the people who feel we've not been given a square deal and we are being disenfranchised, we are being emasculated from the political scene. We shall urge that more during the hearing of the petitions. For now, let us hold the ring. Let us not take away the ring so that we can meet sometime next week. My learned colleague, Mr. Ngoya, and take it from there. No, my Lord, I have finished. My learned colleague, Mr. Ngoya, to say something.
My Lords, my Lady, I just have a few points to highlight. There's a question by Dr. Kamoto on misjoinder of his clients. Let me just make a simple point that the limited question whether the DCJ can constitute this bench under Article 165 Clause 4 of the Constitution, the question of joinder, misjoinder, non-joinder is absolutely irrelevant. It does not bear to that question completely. And that would be a straightforward answer to that issue. Mr. Kamoto also said that this court can sit on any day, at any time, continuously. Section 10, subsection 7 of the High Court Organization and Administration Act 2015 does not support his argument. That section provides, and I quote, the Chief Justice may, where necessary for the expedient and proper exercise of judicial authority, authorize the sitting of the court on any day or at any time. The sitting of this court on any day at any time requires express authority of the Chief Justice under Section 10, subsection 7 of the High Court Organization and Administration Act. My learned colleague, Mr. Nyambodi, made an important point, and I think I support that point. The Constitution says what it says, but it means what the court said. Very crucial point. The Constitution at Article 165, Clause 4, says who can constitute this bench. That is the Chief Justice. Can the DCJ also do it? Is that an administrative or a constitutional mandate? The jurisprudence by this court, as we have alluded to, is 3 cases. The Omtata case, the Kemri case, and the Raila Conchela case. The Omtata case and the Kemri case present that as a constitutional mandate of the Chief Justice. The Raila Conchela case at the High Court level presents it as an administrative function, but we now know that the Court of Appeal has found that to be an arguable point on appeal and has given a stay order on the strength of that arguability. The weight of that jurisprudence militates against finding that this is an administrative decision, as has been urged by my colleagues from the other side. Since I've only 5 minutes, an issue arose here, my lord, my lady. We tried to object, but we were told we will have a right of reply. Professor Jenda presented a piece of paper from his hand, claiming it's a memo from the Chief Justice. We sought clarification on where that paper has come from. First, his argument was it's in the portal. We sought to know in which case file in the portal that paper has come from and why it has no time stamp that is symptomatic of all documents that are lodged in the portal, and there was no clarity on that. He then said Mr. Nyambodi will comment on it. Mr. Nyambodi stood, began and concluded his submissions without commenting on it. He also told us it is in the file. Papers like this will find themselves in the file through affidavits. This is evidentiary material. Again, we were not told which affidavit or which deponent filed on which day. We would therefore urge you that as you consider this matter, you take into account that we have not had a fair opportunity to treat this piece of evidence in its proper context because of the, with respect, woolly nature of the manner in which it has been presented before this court. I urge, my lords, that in view of the matters raised before you, this matter ought to finally clear the position of this court on the jurisprudence of Article 165, Clause 4 of the Constitution, to give it considered thought, and that you return this file back to the appropriate authority, the Chief Justice, to do that which is just and right, as per Article 165, Clause 4. In matters as fundamental as this, in a matter where we all agree that this is a defining moment for our country, we cannot afford to be casual about it. We cannot afford to be expedient about it. It's in matters where a question of principle arises, and of all the 3 organs of government, only one organ stands out for standing on principle, the judicial arm of government. All other arms of government stand on politics and policy, but principle is reserved for the judicial arm of government. We urge you to admit that principle and find that the applicants and their supporters before you have made out a case for you to down your tools in this matter on the strength of the manner in which you are constituted. I rest my case.
My Lord, Chair of the Court, I'm a full-time lawyer, full-time appearing in Magistrate Court, High Court, Court of Appeal, and Supreme Court. I appear before lawsuits and related from time to time. Sorry about this. What you are arguing here is a matter of principle. It has absolutely nothing to do against any of you, either individually or collectively. We are arguing this matter as a matter of principle, saying that things have not been done properly. And it's because, my Lord, and my lady, Kenya is an interesting country. There is a book here which I read from time to time. The Constitution of Kenya Commentary. The Constitution of Kenya Commentary. There is a sentence in this book which is very disturbing. It says this. And so I came in late to this matter. I would have been able to go through and flag a particular sentence. It is, there's a sentence in this book which says this. Kenya is one of the most corrupt countries in the world. In this book, it is written there. Kenya is one of the most corrupt countries in the world. And my Lord and my lady, suspicions are cast on the national assembly. Suspicions are cast on the Senate. And my Lord, we appear before the Lord when suspicions are cast on this court, we stand up and protest loudly. All that you are arguing with respect to, my Lord and my lady, let this matter, when I quote what the management has said, let this matter go back. If he endorses you, he recommends you, we have no problem. She have done her work properly. But let things be done in a proper manner so that we do not send out the wrong signals, so that we do not send out the wrong perception that there is corruption going on in National Assembly, in the Senate, and in the Judicial. Let the matter go back. Now, it was said to you that there are certain individuals who are above the law. That's not correct. When you are appearing before the lordships and my ladies, we should show that actually we are really done in the law. All of us, as land friends, is to keep upon that quite properly. All of us are under the law. The judges are taken to court. The Chief Justice can be taken to court. The Speaker can be taken to court. The President can be taken to court. And in fact, the case of Trump versus Vance, a United States court, 9 Supreme Court judges made it very clear that the Director of Criminal Investigations is at liberty to investigate on the President of the United States. It's my humble submission that I shall be advancing the same argument. That in this case of Gachagua'S, no Director of Criminal Investigation was called or summoned to give evidence. Am I wrong, Mr. Ruto? I'm right. Thank you. I'm glad I'm still right. No Director of Criminal Investigation was summoned to give evidence. This is a lacuna. This destroys the whole case. My Lord, there is something else I would like to say to you, very, very respectfully. Conflicts at work. We are always quarreling with people we work with. It's normal. I happen to know that Chief Justice Miller and Sir James Woods never got on very well at all. They quarreled from time to time, but they couldn't work together. I happen to know Chief Justice Trevelyan and Justice Martin were not friends. They used to throw some things against one another, but they continue to work. Some of us who have been married and so on, we know that actually at times A wife can quarrel, at times a man can quarrel, but they still continue to live together under the same roof to make sure that the children actually have a parent, father and mother. And that's what we are saying. This nation has to survive the crisis. We cannot destroy the nation by saying because of president and deputy president quarrel. That is very, very naive way of looking at life. Yes, thank you very much. And I shall be advancing the argument of alternative dispute resolution. I put them on notice. We shall be advancing the notice, the alternative notice dispute resolution. We can get presidents like Museveni, we can get our archbishop, we can get our retired Supreme Court judges to sort them out and continue to work. But we cannot abandon the Deputy Chief Justice because the two of them could not get on well. That is a very, with respect, that's a very childish way of approaching this. Thank you. By the way, I have a book here that I can donate to you to end our presidency.
I have it also.
Oh, thank you. May I say I'm very happy that your Lordship reads so widely.
I always do. So Senior Counsel Paul, are you responding?
No, in the interest of time, I will go along with the submission.
Then we can give you 1 minute.
Just 1 minute.
Your name again?
Yes, Kimoto, Teresia, Njiro, Kazi, and Tess Kimoto and Company Advocates, Gachagua'S. Yes, I need to respond just briefly on one issue. That is the issue of service. There was an issue raised that the notice was not necessary. And we insist that because today was inter-parties hearing, then the notice was necessary. We also wish to say that one can do a good thing, but at the wrong time. And the reason why we are saying this is that the Chief Justice, though we are being told, we have been given a memo and directed to the portal, which I have checked right now, and it's not there. The last thing that was there was a ruling delivered by Honorable Chief Richard Mwongo at Gachagua'S, and there's nothing else. So the Gachagua'S matters, they have nothing else there. And we have been told this internal memo was filed at petition E14 of 2024. So that is not true. However, we wish to say that once a court sits on Saturday, and then at the wee hours, it could look like a good thing, but then a wrong thing. Because the perception people will have is that there's something fishy going on. That is what we are crying out loud and saying it is not necessary. And the last thing that I wish to note is that justice cannot be served expeditiously while infringing the rights of others. So we are very much in order. Fair hearing is a must. And we cannot be told it's for the interest of quick delivery of justice that will infringe other people's rights. So we are saying let us be heard fairly and we be given enough time to respond to all the motions that are before court and also the petitions or the responses filed so that we cannot be prejudiced. That's all.
I just have one issue to respond, and that is by Professor Guide on the Lordship. Professor was so precise as to the time when the file was transferred from Gachagua'S, that is at 3:45 p.m. The Lordship, I have also taken the liberty to look at the order that was issued in that matter, and it was the order was issued at 3:37 p.m. So in 8 minutes, Your Lordship, the petition E015 was transferred, rather was transferred to the Chief Justice. Your Lordship, in our matter, that is petition E015, it was transferred to Her Ladyship on 11th of October. So those are 8 days. Your Lordship, therefore, we don't understand why the expediency that came in the sense that one petition is transferred to the CJ in 8 minutes, while our petition takes up to 8 days for it to be transferred.
I think the petition was also filed in Gachagua'S, and the lawyers who did that yourself
Yes, Your Lordship.
should answer that question.
Yes, Your Lordship, but that's the
Yes, that is your question to answer. You cannot pose it to us.
Your Lordship, it's in the context of the matter in which.
Yeah, you must balance all issues. You don't, when an issue favors you, you want to raise it up. When it doesn't favor you, you want to put it down.
I'm well guided.
The issue orders which came from Gachagua'S by your orders. Thank you very much. Thank you very much. Before we make final orders, please keep quiet. Before we make final orders, we as a bench, we want to thank all counsel for the mature way in which we have conducted today's proceedings and the legal arguments which we have put. We are going to assist us to reach a decision which we shall render tomorrow at 3:30 p.m.
Your Lordship, before you pen off, there could be a possibility, Your Lordship, that it is imperative that we have the other files that are not before you coming up for a mention tomorrow, because there is an application for the recusal that I have filed. I would perhaps also wish to seek directions on it.
May it please the court. Once more, my name is Dr. Eboso, and I'm still beseeching the court that there are other petitions that were filed on this same matter, and which applications were made, including temporary injunctions, but which were not given, and which it would be good use of judicial time if the petitions and the applications therein were had together with the applications that are in this matter. And I would like to point out that if this bench, which is a high court, proceeded to hear the issues that surrounding the conservatory orders in this application, the 3 applications that are before this bench, absent the participation of the applicants in all those other files which have already been filed, we would suffer prejudice, because we would be arguing applications after the court has already sat, and we would be reinviting the court to argue the very same thing. So I would wish, as the court retires, to consider that. Thank you.
Okay. Maybe before the Honorable addresses, I just want to make this clear again.
Yes.
We will not deal with any file in which we have not been empaneled. If you filed a petition and it is yet to be empaneled, it is upon you as counsel to follow it up with the deputy registrar of the court. First of all, we have to ascertain whether you applied for empanelment, because it's not automatic. If an order for empanelment was made, follow it up. That is the only time you can know what happened. When the file is empaneled, comes before us, we will deal with it. For the matters which were empaneled, and maybe they are not here, we presume they are not before us because we were not moved. We have handled the matters today because we were moved by an application. If you feel we need to look into that matter expeditiously, you may have to consider. But at the appropriate time, we will issue comprehensive direction on all the matters which were paneled with which we are paneled, even if there will be no applications. So let us get it clear so that as we move forward, we avoid this back and forth of getting us back to matters which were either paneled or not paneled. Let's be focused. We will deal with every matter, but now we are dealing with matters where we have been formally moved. Thank you.
Yes.
Thank you.
Very well kindly, and we do thank you for holding the flag of justice and so forth.
My Lordships and my Lady, on behalf of the respondents, I want to thank you for according us audience this afternoon to this evening. I want to thank you for your patience, and as the titular head of the bar, I want to encourage my learned friends that we must continue being respectful, professional, and holding the dignity of these courts very highly, and protecting the dignity of the courts and the dignity of our country. Thank you so much, and have a blessed evening.
Thank you. May I, sorry, I like talking. May I say that I am most grateful to the remarks of the Honorable Lady Attorney General. And if I may say so with respect, in most recent times, she has shown that the court must be respected by herself personally appearing in court. There are some previous Attorney General whose name I would not like to mention, but who are full-time office workers. Thank you.
So we reconvene tomorrow, the 23rd of October at 3:30 p.m. Thank you.
People Daily, we believe small actions lead to monumental changes. As we commit to a greener future, embrace simple steps, reduce, reuse, and recycle. It's time to go green. Kua Green. Switch off unused lights. Opt for reusables over